Wonderful. Shall we get started?
Let's do it.
Excellent. Welcome to the University of British Columbia Allard School of Law. We are situated on the traditional, ancestral, and unceded territory of the Musqueam people. And we are gathered today for a public law panel called Canada, States of Emergency and the Emergencies Act. Just last month, the Canadian government declared a national public order emergency under the Emergencies Act to end the blockades, occupation, and protests in the city of Ottawa. This recent state of emergency follows other COVID-related emergencies, and it recollects some of the issues that Canada faced after 9/11. This is the focus of today's panel, which will allow us an opportunity to reflect on these states of emergency. We will consider lessons from the past, as well as key future implications. My name is Yuvraj Joshi, and I'm delighted to moderate today's conversation with three expert colleagues. First is our convener, Mary Liston, who will set the stage for our conversations by covering the basic meaning of a state of emergency, the older and contemporary history of states of emergency in Canada, with a brief recap of current events, the actual legislative framework, the law, as well as the rule of law and democratic accountability considerations, and finally, some future implications. Second, we will hear from Professor Jocelyn Stacey, who researches emergency laws with a focus on climate-amplified disasters. She works closely with the Silcotin national government on indigenous jurisdiction in times of crisis. And Professor Stacey today will address the complex layering of emergency laws across Canada's multi-jurisdictional landscape. Our final presenter at the end will be Professor Debra Parkes, who is interested in the possibilities and challenges of using rights claims and strategies to address injustices, with a particular focus on criminalization and incarceration. Professor Parkes will situate the recent invocation of the Emergencies Act in the context of policing and criminalization of other protest movements in Canada, as well as breach and enforcement of charter rights to protest. We will now hear from our three esteemed presenters, followed by a Q&A with the audience in person and on Zoom. Professor Liston, thank you so much for bringing us together, and please take it away.
Thank you, Professor Joshi, for that wonderful introduction. Can everybody hear me online and in the audience? So first, I want to thank my colleagues on the panel for taking time out of their very busy schedules this term to talk about the state of emergency that we recently experienced. And also thank you to you and the audience online and in person for coming to listen, and I hope for sharing your thoughts, reflections, and questions. It seems so long ago now, but it seems to us that it is important that we not forget what just recently happened in Canada, despite the fact that international events seem to have overtaken our attention. And I'd also like to extend a thank you to the many people who helped communicate, organize, and make the technology work for today's session. So that would be specifically Michelle Birchall and her assistant Tess, Robert Quay, and Rowan Sheehan. So as Professor Joshi stated, and already we have our first technical issue. I think, is the power on for sure on that? Well, it was when we last used. Okay. Yeah, maybe just activate it. Do I need to move closer? Oh, no, that was Jocelyn, not me. Oh, wait, here we go. Okay, wait. Jocelyn, are you moving it or am I?
I'm not touching anything.
Okay, there we go. Now it's problem, whatever it was. We're back on track. Gremlins. So yes, although we might all monitor that for the next set of slides. So as Professor Joshi set out, I'm going to do a brief overview of states of emergency, the history, and the context. Most of my presentation will be looking at the law itself, and I hope that will set the grounds for the discussion, pointing out some issues with the legislation and the regulation on the proclamation. And then the last will be implications, which my colleagues are really going to spend time exploring the many fascinating implications of our state of emergency. So although it only lasted 1 week, it was the week that was in Canada. Largely happening over our reading week, and hence a slight delay in thinking about it in Allard law. We start with a general meaning, and this is a typical Oxford English Dictionary understanding of a state of emergency, which we know to be a national danger or disaster. They come in many shapes and forms. We've had several environmental disasters, of which Professor Stacey has provided analysis of in her own work, which the government suspends normal constitutional procedures in order to regain control. An older terminology is called martial law. Partly because it involves often the use of police powers of the state, and in certain situations, the military has been called in. This links to another literature, one we generally don't consider in our JD program, which is legal and political philosophy. And in legal and political philosophy, a state of emergency is often termed a state of an exception. So they're kind of cousin terms. Two sources of thought for thinking about states of exception are political philosophers Carl Schmitt and Giorgio Agamben. I don't know if anyone in the audience has read them, but they are certainly well known on these issues. And this is a quote from a book called Political Theology by Carl Schmitt, who was a political philosopher in Weimar Germany in the 1920s. And his essential nutshell understanding is sovereign is he who decides on the exception, a state of an exception. And in the context of Schmitt's work, a state of exception is essentially extra-legal. In his words, the Constitution, the constitutional framework, and even the legal system itself fades into the background. And it is executive power that comes to the fore. And at least in a parliamentary system, it's the political executive who claims supreme authority and indeed claims to be the sole legitimate sovereign authority in the political community. We can see that states of exception therefore engage in the more conservative side of the rule of law with a focus on preserving order and peace and the preservation of society, and that they can come at the expense of the more, I would say, progressive values of the rule of law when laws are used to protect civil liberties, fundamental rights, ensure freedom of individuals, ability to communicate, freedom of the press, and so on. There's also the danger that even with this nutshell definition of a state of exception, that the executive may not be under obligations to justify the exercise of public power in a state of emergency. This has obvious implications for citizenry and the role of the courts, which we'll talk about. And another concern that arises out of the general definition that we can see is we should be concerned about abuses of power by the executive branch in particular. But there's also that the power that is used or the laws that are made in a state of emergency may be actually ineffective and counterproductive. And I think that's going to be the source of some conversation today. A very brief timeline, predating our current legislation is the War Measures Act. And so some of us may have taught aspects of the War Measures Act as part of first year JD public law and the charter course in the Edwin Gray case, where the Supreme Court gave a very, very broad scope to executive power to pass regulations without scrutiny through Parliament. As we'll see, a number of issues recur when states of emergency are declared. And so in the context of World War I, we had compulsory conscription, but other consequences were censorship and the arrest and detention of so-called enemy aliens at that time, which were Canadians of Ukrainian, German, and Slavic descent. The second use was in the Second World War, again used in order to regulate and control in the face of perceived internal and external threats during wartime. Some consequences in that incident were the turning away of a ship containing 900 Jewish refugees from Germany, and many of them sent to their death in concentration camps subsequently, as well again as designation of certain groups as enemy aliens, and in measures well beyond what happened in World War I, the ill treatment of Canadians of Italian, Japanese, and German descent, including detention, deportation, seizure of property without compensation, and a number of other wrongs. The third instance is the October crisis in 1970, and this is the first time that the War Measures Act has been used in relation to peacetime activities. As many of you will recollect, this was a result of insurgency by our own domestic terrorist group at the time, the FLQ, who had kidnapped officials and indeed executed one of them ultimately. Prime Minister Justin Trudeau, as many of you may have seen on YouTube and other sources, this is his just watch me moment in response to a question about how far he would go in order to restore peace, order, and good government, and his response is just watch me. Again, some of the consequences are the suspension of civil liberties, the bringing in of armed forces, 1,000 soldiers at that time in order to restore order, and the arrest and detention of many individuals, both in Ontario and Quebec, who were suspected of supporting the FLQ. As a result of this history, the War Measures Act eventually, and partly due to the product of the introduction of the Charter, was scrapped and replaced by the Emergencies Act. So the Emergencies Act is a direct response to the changes of a new constitutional order in 1982. Two key features are that this legislation is subject to the Charter, as well as actions taken under it, and that we have further role for Parliament. Nevertheless, it is now 30 years old, and time has moved on. We've had September 11th. And the results in our public law order, including massive anti-terrorism legislation and the securitization of the state. And we've now had two other kinds of emergencies, the global public health emergency of COVID, as well as the Ottawa long haul occupation that Yuvraj gave us a little summary about, and which we'll talk about more. And certainly, this year, is the time that the Emergencies Act evoked for the first time in relation to a domestic dispute. So it's 35 years old. Is it up to the task is one question. And if not, what reforms are needed? So I'm going to walk you through some of the key provisions. The first is there's a definition of a national emergency in the Act. This is a general definition. And you can see that the legislation establishes thresholds that the government needs in order to justify the introduction of regulations, as well as to justify any actions that it's taken. We can see that it requires serious endangering life, health, or safety. And importantly, and that I believe Professor Stacey will talk to, that this situation exceeds the capacity of the authority of a province to deal with. And that is one threshold that has been subject to some questioning. The second is that it seriously threatens the government of Canada to preserve sovereignty, security, and territorial integrity. And again, there are some doubts about whether or not that general threshold has been met. And then thirdly, and often that's in the House, but also outside of the House and in the academic community, I would add. And third, that the situation cannot be effectively dealt with under any other law of Canada. And there are certainly a lot of concerns that the plethora of laws that were available to the federal government, as well as the ability of the province to act, should have been enough to meet the situation without evoking the Emergencies Act. And we can think about the use of criminal law, municipal law, traffic laws, border laws, quarantine laws, tort law, any number of laws were at disposal. But some combination of the unwillingness of the local police and the civil authorities, the attitude of the protesters who had a certain belief in unconstrained freedom, and just the general complications of states of emergency led to a fair bit of delay, leading to the question about whether or not the invocation was necessary at all. We have different kinds of emergencies. COVID, for example, is a public welfare emergency. The Ottawa situation is classified as a public order emergency. And again, we see certain specifications about what it means. So this is in conjunction with the general definition, but emphasis on the security of Canada and the seriousness of the situation. And that if the government is wanting to justify that there are threats to the security of Canada, that justification is linked up with the meaning of security in the Canadian Security Intelligence Service Act. And I did not put that definition into a slide, but suffice it to say that that's a very high threshold, invoking concerns about espionage, sabotage, foreign influence activities that are trying to undermine or overthrow the government, and acts of serious violence. And so we can see there are some seriously high thresholds that the government is compelled by law to meet in the general legislation, let alone what justifications they may have to provide under a charter challenge. Section 17.1 is setting out the power to declare a public order emergency. And we can see that, again, thresholds are reasonable grounds, so not as high a threshold, that an emergency exists, and that there are special temporary measures, so specified legislative intent that all measures are supposed to be temporary. And then we can see the contents that we might think about rule of law requirements here, that a declaration of a public order emergency has to specify concisely the state of affairs. And I'll return to that in a slide, in 2 or 3 slides, that they are what the special temporary measures are, and if there are any geographic constraints, or if it is actually at a nationwide level. The consultation is that the government is also obliged to consult with Lieutenant Governor and Council of each province or territory who may be affected by the state of emergency. This is setting out the ability to make such orders or regulations with respect to the following matters. And we can see that there are, and I'm not going to read them, no, so don't worry, but that they are broad and many, and that most of them engage charter rights and freedoms, certainly all of the Section 2 freedoms, potentially Section 7, life, liberty, security of the person, because there are implications for being put in jail, and Section 8, unreasonable search and seizure, including general questions about whether or not any of the measures are necessary and proportionate. This is then the proclamation that was issued by the Governor General, Simon, declaring a public order emergency. And you can see in the first line that the specification content requirement concisely is satisfied. We do specify the emergency to be constituted. And here is why. And these are why we're going to take special measures. Of course, this begs the question about whether or not it was actually necessary. Many of these incidents had been taken care of by the provinces on their own. Certainly the blockage at the Ambassador Bridge had been taken care of by Ontario, as well as the guns and the protest at the border dispute in Alberta. But certainly the federal government felt that it was entitled to read this as threats that extended in particular locations in Canada, but also had nationwide implications. At the time, you remember, there were all sorts of allegations that there were American, Chinese, and Russian influences being involved with the blockades as well. Here are the list of the special temporary measures that may be necessary. And again, this is supposed to be measures that no other law in Canada can take care of. Again, the threshold may not be met. And the one that I want to just briefly focus on is C, which is measures about the use of property, funding, crowd platform, payment processors, transactions. So this, I believe, is the one area where existing laws may not have been sufficient in order to enable the government to act. And so there was a bit of a gap in our financial regulatory framework. And so really this is allowing government to follow the money. It's also going well beyond what happened in COVID for co-opting private persons, such as corporations, into participating in emergency responses. So we were used to airlines assisting with COVID, but now we have banks, financial actors, internet providers, funding platforms, and a number of other financial actors who are going to be compelled to comply with government directives in order to suss out how monies were provided and for what reasons. This obviously has accountability concerns about misuse and privacy concerns. There are 2 associated regulations that are coming out of the declaration or the invocation of the Act. The one I've chosen to focus on is the Emergency Economic Measures Order, coming from this ability to further regulate financial transactions. And so the duty to cease dealings is located in provision section 2. And it's any entity must, upon the coming of force of this order, cease to deal with property, to facilitate any transactions in relation to the occupation, blockades, or political movement. These are extraordinary powers. And it means ultimately that we can no longer be quiet supporters of political causes. So there may be some future implications for the use of financial powers in order to constrain political expression and activity. It allows banks to freeze personal and business bank accounts, credit cards of protesters. They can do this without obtaining a court order. All information is reported to FinTrack, the financial monitoring agency at the government level. All suspicious financial transactions are to be reported. Obviously, there are concerns about crowdfunding, suspicious transfers, both in Canada and in other jurisdictions, a transnational problem related to crowdfunding platforms. And banks have some immunity against being sued for the participation with government action. And then the last thing I want to focus on are the rule of law and democratic measures that have been put into the Emergencies Act. The first is that Parliament must approve, authorize a proclamation or declaration of emergency. Government must explain the reasons and report on the consultation that it's had with provinces. So we can also see federalism obligations being baked into the legislation, and that they must be put before both houses of Parliament in order to be authorized. The Emergencies Act also mandates a review by a parliamentary committee. This is setting out the authorization and the membership. The parliamentary review committee has been struck. We might want to talk about that in the question period, and that it has certain representational requirements. The parliamentary review committee will report on the causes and the exercises of power. And there will also be a later inquiry into the circumstances that agency that was invoked. And then lastly, I want to, I don't know what happened there. This thing is going crazy.
Can we go back?
Yeah. I think I'm pressing to go back. Now nothing's happening. Okay, yeah, Deborah, why don't you just take over there?
This one's not.
Maybe it's me to work. There we go. So basically, I've set out some of the implications about setting a precedent, whether or not the Emergencies Act is sufficient, and we might want to talk about these things, obviously concerns about executive accountability and overreach. And then the next set of implications are really what my colleagues are going to talk about in terms of rights, federal, provincial relations, Indigenous relations, and political activity. So I will leave it at that and turn it over to Professor Stacey.
Thank you. Well, thank you very much for the invitation to speak. I'm nervous about taking up the clicker. We'll see if it works. There, okay. So
promising.
We'll see what happened to my slides. Yeah, that's okay. All right. So I'm going to do sort of a bird's eye view, a very quick and woefully inadequate overview of the multi-jurisdictional nature of emergency law in Canada. Just expand on what Mary's set out so far. What I'm going to try to do in just a few minutes is going to add 3 layers of jurisdiction to the conversation. Once I've done that, I'm going to tell you 2 very short stories on what I'm calling the jurisdictional over-under reach, so that you get a sense of the struggle and the potential tools that are and are not available when jurisdictions are trying to work together in times of crisis. And then I'll leave you with a parting thought on a very oversimplified hypothesis about why we struggle with this. And this screen has messed up my very nice slides, so I'll just preface that. They look a little bit funny, but hopefully the content's all there. So let's just start. So there were titles, but this is a timeline, which you can tell without a title, of the trucker occupation in Ottawa. And what I want to point out is that there are 4 jurisdictions that are engaged here in this timeline. So, and notice the ordering of this. So under February 2nd, you can see there was a joint statement issued by the governing bodies of the Algonquin Nation, stating that the convoy did not have their consent to enter onto their traditional territory, and that a number of traditional protocols were being violated. So, right, Indigenous peoples, traditional landowners speaking first about the unlawful occupation of their territory. Then, right, 3 levels of Canadian jurisdiction being scaled up in terms of who is sort of most directly implicated by the occupation. So first, the city of Ottawa declares a local emergency. 5 days later, the province of Ontario declares a provincial emergency. And then after that, Canada invokes the Emergencies Act, as Mary has covered already. So let's now talk about provincial and municipal jurisdiction, because those are covered by the same pieces of legislation. So there you can see what we've already covered in part, right? The Emergencies Act is that basic public law architecture for the federal invocation of a national emergency. Thank you. And so let's see what happens if the province, so there we go. Provincial and municipal jurisdiction will add these layers here. So provinces and territories have emergency management legislation that basically mirrors and structure the Emergencies Act at the federal level. So what that means is it provides a framework for declaring an emergency and for authorizing the use of particular emergency measures that are necessary to respond to that emergency. And so I've just shown you that how those measures were used by Ottawa and Ontario in this case. Unlike the federal legislation, we have ample experience of the use of these provincial and municipal powers under provincial legislation. So the most common emergencies that we face in Canada where we rely on these powers are from natural hazards, so floods, fires, and other extreme weather events. And so these actually get invoked with quite a bit of regularity. Now, there are some constraints on the provincial and municipal side, obviously territorial. Provinces are limited to dealing with their own geographic region, and similarly with municipalities. In addition to that, depending on the provincial legislation, municipalities may have a smaller range of emergency measures that are available to them. All depends, right? First rule of public law, read the statute, right? So it all depends on what's in the statute. And they're subject to unilateral provincial override. So a provincial minister or lieutenant governor and council can step in at any time and cancel a municipal emergency. Now, these interact in all sorts of interesting ways without the invocation of the Federal Emergencies Act. So it does happen that emergencies overwhelm the capacity of the province to deal with the particular event. And what often happens in that case is that the province or the municipality or both will call in support from the federal government. So that support can come in the form of funding, it can come in the form of equipment, it can come in the form of extra enforcement personnel, whether it's the RCMP or the military. So the military, Mary referred to what happened in the FLQ crisis. More commonly, the military will come in to fill sandbags and lay sandbags, right, in the face of a major flood. So these are standard operations that we have a lot of experience with. I'm actually not sure, maybe anybody here knows and followed this a little bit more closely, whether Ontario called in this support in the earlier days of this occupation. We do know that Alberta did request more support for dealing with the blockade at the Coutts border crossing. And we know that municipalities called in extra support from both the provincial and federal government. So both the city of Windsor and the city of Ottawa called on both of them for support. So we have multiple levels of jurisdiction already engaged in these blockades within the province of Ontario and also Alberta, already seeking out ways to find a coordinated response, at least in terms of enforcement. So I just want to pause here and consider the question of accountability. So which level of government is the best level of government, in the best position to manage the emergency response in terms of actually bringing about an effective response and in terms of being the appropriate level of government to deal with it. And I'll just call on the principle of subsidiarity for a moment, which is a principle that informs Canadian constitutional law, albeit maybe in incomplete ways. And the principle of subsidiarity is that issues should be addressed by the most immediate or local level of government, because that's the government that is most responsive to the affected community. So it's a democratic principle that informs our federation. And we saw this in the timeline of the occupation that I showed you, right? So the scaling up of levels of jurisdiction. But I also want to flag for you a different principle of, not a different principle of democratic accountability, but a different way in which we concerns about democratic accountability arise within the structure of Canadian emergency law. And that is that there are much better mechanisms for transparency and oversight in the Federal Emergencies Act than there are in provincial and territorial emergency management legislation. So Mary ended her presentation by highlighting a couple of these, right? So you have to come before Parliament for the emergency to sort of take effect, right? That happens right after the declaration. Then there's a parliamentary review that is required. And then there is an inquiry that follows after that, hopefully an independent inquiry that happens after that that's also required by the legislation. These things do not, by and large, exist in provincial emergency management legislation. In Ontario, there is a requirement for the premier or the emergency management official to issue a report before the Legislative Assembly, sort of here's what we did and why we did it. In BC, there's nothing. Okay, so it's purely executive, delegated power to the executive. So there are countervailing concerns around democratic accountability within our existing structure of emergency management legislation. Now let's on to this Indigenous jurisdiction. So you all know, alongside institutions of the Canadian state and alongside Canadian law are Indigenous legal orders and Indigenous governing bodies. And so let's start with inherent jurisdiction, right? So Indigenous peoples exercise inherent jurisdiction as self-determining peoples. What does this mean? It means that there will be Indigenous-led emergency responses, right? And so what that might look like are measures that are very similar to Western legal tools, right? So if you think about over COVID, that could be travel advisories and border controls, which we saw across the country that were affected by Indigenous peoples across the country. Or it could be something very different. So it could be, for instance, a culturally specific approach to evacuation orders, recognizing a long history of forced displacement on traditional lands, and the parallels between evacuation centers and residential schools, right? So those measures might look very, very different when they're being led by an Indigenous government. Within the Canadian framework, so let's think then about how does that get recognized by the Canadian legal institutions. And there are a few ways, which hopefully you can make out from this slide. So one is through one way of expressing those different approaches or sort of specific approaches to emergency response can be through bylaws issued by a band council under the Indian Act. So exercising a form of delegated federal jurisdiction. And that does happen. There is a specific provision in the Indian Act, highly specific provision in the Indian Act that allows for bylaws relating to the health of residents and to prevent the spread of disease. So you can see in there a very particular history in this land with epidemic impact, pandemic impact on Indigenous peoples. And so Indian Act bylaws can be one way of giving effect, at least in theory, to an Indigenous approach to emergency response. This can also happen through negotiated jurisdiction. So whether those are modern treaties, other forms of government-to-government agreements that deal with territorial management or service provision. But what does the practical reality look like? And this is a paper that I'm working on right now. The practical reality, in short, is terra nullius. So there's basically the very little recognition of Indigenous jurisdiction in the aftermath of a crisis. It's forgotten, ignored, or erased. And part of that, a big part of that is our colonial, ongoing colonial system, but also the sheer complexity of navigating jurisdiction in times of crisis. Okay, two very, very short stories here to highlight how jurisdictions interact, the various sort of legal tools and challenges of coordination, and I guess maybe to set up in parallel to what Deborah is going to be talking about. It's not just individuals that are concerned about the way in which governments maybe overreach, right, or under respond in times of crisis. It's also other governments that are concerned about what their counterparts might be doing. So let's go back to the trucker occupation, for example. Yeah, okay, so this it doesn't quite work. So here we've got one clip of the city of Windsor, right? So one level of jurisdiction. seeking, right, so I've mentioned already, Windsor has asked the province and the federal government for additional enforcement support. Alongside that, trying to use other legal tools to shore up its existing jurisdiction, right? And so using an injunction proceeding to attempt to clear the blockades on the Ambassador Bridge. Beside that, you would have seen a picture of Jason Kenney, which I'm sure you can all picture, with a news article where he's talking about Alberta proceeding with the legal challenge to the invocation of the Emergencies Act. And so as Mary described earlier, right, we get this sort of very confused, ineffective response on the ground where we're asking for more coordination from higher levels of government, more help on the ground. It doesn't seem to be working. And then the potential federal overreach in the use of the Emergencies Act. And so now we'll have this legal challenge that will go ahead to the federal court, the argument being that the requirements of the legislation were not met in this case. The second story, so on the left, you'll have to picture an image of BC forests on fire, which again, I'm sure you can imagine because of our recent history with this. So it was a news story from this past summer where local communities in BC in the interior were dealing with another season of extreme wildfire, demanding the province declare a provincial state of emergency. Imagine that, right? Asking for the invocation of emergency powers because of how dire the situation seemed to be on the ground. There's no legal mechanism for this, right? So cities are trying in this case to pull some political levers to put pressure on the province to make this declaration and use some exceptional measures. A regional board unanimously passed a motion calling on the province to declare a provincial state of emergency. And a few days later, the province in fact did, because it was another bad wildfire season here in the province. But even when communities are asking for these exceptional powers to be exercised by another level of government, the potential for abuse and the potential for an overreach are still there. And so this goes back to the work that I started years ago with the Tsilhqot'in National Government back in 2017, when that was then the most extreme wildfire season we had ever had. The RCMP, emboldened with these exceptional emergency powers, going and threatening to take away Tsilhqot'in kids because the chief wouldn't sign off on an evacuation order that's not in fact applicable to reserve lands, which are federal jurisdiction. So here you have a couple of examples of conflict, overreach, and abuse, right? Trying to grapple with the multi-jurisdictional nature of these emergency responses. Okay, so some parting thoughts here. Where does this leave us in a complicated morass of jurisdiction? So these public law mechanisms, right, the framework that Mary set out and what I've attempted to add to for declaring an emergency and authorizing emergency response measures, they are important. They're important pieces of an emergency response, and in some cases need to be invoked. But despite having sort of parallel and complementary emergency powers, they're insufficient, right, on their own for a coordinated multi-jurisdictional emergency response. And so the hypothesis, an oversimplified hypothesis, is that I'll just leave you with, that either coordinated or uncoordinated emergency response is not in fact dictated by the legal frameworks that we've just talked about. It's actually dictated by the interjurisdictional relationships and mechanisms that pre-exist the emergency. And just to bring this back to where we are today, I think that's why the inquiry, why the parliamentary review are really, really crucial, because what comes out of that is then going to dictate the way in which we respond to the next event. Okay.
Okay, well, I'm going to hope that my slides show up. Oh, okay, yeah. And I'm going to also hope that they look something like how I put them onto my computer, but I think there might be like a Mac do you use Mac? Yeah. I don't know if there's a compatibility issue here. In any event, really want to thank to Mary Liston in particular for kind of spearheading this event and bringing us together, and for my wonderful colleagues for participating with me. And I was, I'm grateful for Yuvraj for giving the territorial acknowledgement, because I was going to also do that and say that in talking about protest and dissent and what constitutes an emergency under Canadian like settler colonial law, I'm mindful of the ways that Indigenous peoples' resistance to, to the occupation, dispossession, theft of land and children, and all of that has been criminalized and continue to be criminalized and punished in a whole range of ways. And so it's really important to be thinking about our place, as a law school on these lands in the context of all that, and then thinking about the law's role in responding to these emergency events with extraordinary powers. So I'm going to briefly talk about one of the constitutional challenges that's been brought to the invocation of the Emergencies Act, not the only one, but there's a couple that are similar, and then there's, of course, the jurisdictional one that Jocelyn has mentioned. And I want to just kind of, I guess, zoom out a bit and think about the other kinds of protests and other kinds of responses that we've seen in recent years in Canada. I want to talk briefly to kind of contextualize the convoy and think about how attention to the context of different kinds of protests may matter, and how we think about the legal responses to those and the constitutionality and, just what is done in response. And then just a few words on maybe the kind of future and what some maybe concerns or worries about the future as a result of what we've been seeing recently. Very shortly after Prime Minister Trudeau made the announcement of the invocation of the Emergencies Act and the order, and the declaration under that act, the Canadian Civil Liberties Association announced that they were filing an application for judicial review in federal court to challenge it. Interesting, much was made about in the media even before this announcement by the CCLA, on the day when everyone was quite surprised by this announcement, actually, like it wasn't something that was anticipated, I don't think, by most people. There was a lot of discussion in those days before that about what might be done, but it seemed it came quite suddenly. But a lot of the media focused on, kind of the talking point of the Charter of Rights. It's contemplated in this act. It's right at the beginning of it. It's all in compliance with the Charter, which was in contradistinction to the War Measures Act. And very clearly they're very different acts, and there's a history behind that. But it's just kind of interesting that there was sort of a sense that it's okay, it's all Charter compliant. And then, very quickly that message changed, at least for some, and certainly many in the legal community, and certainly the Canadian Civil Liberties Association and the Canadian Constitutional Foundation both announced that they were filing these challenges. There's an interesting history about the CCLA because I don't know if people have read, but David Schneiderman, who's a law professor at U of T, constitutional law professor, wrote an op-ed recently where he talked about actually having been working at the CCLA when the Emergencies Act was passed, and how the CCLA was actually quite involved. Alan Borovoy, then executive director of the CCLA, very well-known and a civil libertarian and committed to reining in police powers and censorship and a whole range of those kinds of government actions. The CCLA was involved in, and actually invited by then Defense Minister Perrin Beatty to assist with trying to make this thing more, to increase oversight, to make this more palatable. And I think that had a lot to do, as my understanding, with negotiations around bringing Quebec, into the constitutional fold, and attempts around the Meech Lake Accord, which were around the same time. But also this was one way, because of how the War Measures Act had been, and Trudeau Senior's invocation of it had been understood. So there's a very interesting kind of history of some of the oversight mechanisms in the Act, apparently CCLA having been quite involved in advocating for that. And so in any event, you have as Mary nicely kind of laid out, the threshold requirements for emergency proclamation. That is one of the things that's being challenged in the legislation brought by the Civil Liberties Association, is that the whole basis for the emergency orders, which are the emergency measures regulation and the emergency economic measures order, that those and the powers that undergird them are illegitimate and unjustified limits on rights, because the threshold in the act itself is not even met, right? And so I actually did look at the CSIS definition of threats of to the security of Canada, and I think the government is relying on C, activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective within Canada or a foreign state. So what is the emergency is such an interesting and important question in all of this. And if you analyze and look at what the Prime Minister Trudeau has said, what is in the actual documents, I have all the orders and stuff here, I printed them out, and the declaration, it is very much focused on economic issues, economic concerns, an economic emergency. This is what really got the government's attention, I think. And so you have the allegations around threats of violence, use of acts or of serious violence against persons or property, as there's not a lot of that on the facts here, right? There's just not a lot of it. There's concerns around rhetoric, and the rhetoric in social media and in the links between these the leadership of this the protests, as some have white supremacist leadership links, and many there's certainly those facts are on the record, I think, around some of the leadership. But in terms of actual the level of threats or the level of use of acts of serious violence against person or property, it's arguably a little more tenuous when so much of the focus is on the economic impact. So in any event, and this really crucial question about whether it was really an inability to enforce the law or an unwillingness to enforce the law by the province in particular and the municipality with delegated provincial powers. But I'll leave that to others to maybe say more about. But in terms of the charter arguments, there are significant arguments being made here around the very obvious impacts on peaceful assembly, travel to and from assemblies that may reasonably be expected to lead to a breach of the peace, liberty rights in terms of imprisonment, search and seizure in terms of the increased powers around FinTrack, or the tracking and seizing of assets. So I'm happy to talk in the Q&A if people want about that, but I want to think about this protest, or sorry, this emergency response and the concerns around charter rights that arise in this context, in the context of the broader context of protest in Canada. And I say here, all protests are not created or treated equal. And by that, I mean that we have had, very significant police, military, surveillance responses to a whole range of protests in Canada in just the last 15 to 20 years in particular. And so all of these ones on the slide here are actually within the last, 12 years. And the top left is the G20 protests in Toronto and the kettling of protesters. 111 people were arrested during the G20 summit in 2010 in Toronto. Mass detention in purpose-built commandeered sort of warehouses for over 1,000 people. I actually wrote an article a number of years ago with a law student of mine at the time who had been a legal observer and was one of the people arrested in protests. And we wrote about the use of the breach of the peace power, which is a very broad power at common law and under our criminal laws in Canada that is still used in the policing of protests. And that policing enterprise cost over $676 million. There's a class action suit after the fact where there was some compensation for people, unjustifiably detained and arrested. But it was an example of the existing legal tools being used in a massive response to a threat that certainly there were some concerns about some behavior, but acknowledged to be a massive overreach of police powers. There's also Ferry Creek on the bottom right. There have on Vancouver Island, there have been already, as of December, 1,200 arrests there, nearly $7 million in policing costs. There's on the left the military and RCMP destruction of the Wet'suwet'en camp at in northern British Columbia, and the massive police surveillance and responses to that. And then I have on the right hand the truck protests, and I just have the police kind of sauntering by. And obviously that wasn't what happened in the end. But you do need to kind of put these things in stark contrast, the way that the police responded at the for the most part to this convoy, as quite different from others. And so just in terms of further contextualizing the convoy, this is just on the left some data through access to information that the Intercept journalistic website they received about the donors to the Freedom Convoy, and the significant number of donors from the U.S. There's been journalists have crunched the numbers and seen that the top 200 American donors have names matching those of donors to Republicans and to former President Trump, and significant. So there's a very interesting, I think, difference in this protest. In that the way that the connection between some far right groups in Canada and groups on the far right, or certainly on the Republican side, which I would consider far right in the U.S. In terms of influencing a protest in Canada. And this is again to be, I think, looked in context with the response in Alberta and the way in which the Conservative government in Alberta has tried to really make an issue out of the non-issue of foreign involvement in and foreign money in environmental protests in Canada and in Alberta in particular. We have actual quite significant evidence here. There's nothing in the inquiry that was conducted in Alberta, and at least to my knowledge, that looks anything like this. And this is just over a few days. And so I think we do need to attend to the different contexts of these protests. I'm aware that my time, I think, is probably up, but let me just say that I think we can hold two things, at the same time, or I try to in any event. And one is that the Emergencies Act can be an unconstitutional overreach and normalization of extraordinary police powers. At the same time, we can have concern about the growth of far-right organizing in Canada and its normalization and connection to policing and law enforcement. And concern also about who is likely to bear the brunt of the normalization of these the invocation of the Emergencies Act in relation to arguably tenuous grounding as an emergency. And, it was short-lived here. There are concerns about whether it's charter compliant, and I think those need to be aired fully. But I also think it's useful to think about, and I'm going to draw on Emily Kidd-White, who's a scholar at Osgoode Hall, who talks about the politics of attention. And what gets our attention in law and in terms of injustice? And what harms do we notice? What harms do we mobilize around as lawyers and those considered thinking about rights? And whose rights do we see? Is it easier to see? And whose do we see, kind of less easily? And we are less likely to kind of to see the need to protect and be critical of government responses. So I guess I'll leave it there, and hopefully we have a little bit of time for discussion now.
Thank you, professors, for those really illuminating presentations, setting out the contours of the law and the policy debates, the normative considerations so clearly and compellingly. I'll just highlight the work of historian Audra Deepti, who has written recently about this in the context of racialized history of protests in Canada, and has asked some questions that we should think about, including why did it take so long for the police and governments to protect Ottawa residents and businesses from reportedly volatile protesters? Did Canada's white supremacist practices guarantee participants in the so-called Freedom Convoy minimal police and state interference, as they assumed the right to occupy public space while displaying racist symbols and simultaneously claiming to fight for freedom? And if the convoy was organized by Black and Indigenous groups, would the response by both the police and government have been more severe? And this is situated in a larger history that Debra has just pointed us to. So with that, we welcome questions from audience in the room and online. And we have a question right there. Would you mind identifying yourself and posing a question?
My name is Eric Keelback. I'm a law student here at Ottawa Law Student. It seems to me that there's sort of two elements in thinking about how the Emergencies Act was invoked, in the sense that, like, there's sort of a legal question of, like, did the state of emergency meet the standards? But also, and I think this is something you all alluded to in your discussion, was in a normative sense, like, is this a good way? Is this a good use of state power? Is this an overreach of state power? So I guess sort of like my question to the panel broadly would be, do you think the government was correct in invoking the Emergencies Act on these two sort of aspects, the legal question and also the normative question?
Do you want to repeat the question for people on Zoom? I don't know if they.
I think they will have heard.
Okay,
Yeah.
okay, good. Who wants to start? I mean, I guess I'll just start by saying, I think there are very legitimate and real questions about whether that threshold was met here in the Emergencies Act. Having said that, I'm going on the basis of the evidence that I have seen in the media. And this is always the question, this is always the issue with when you're talking about national security, and this is very much invoked as a public order emergency where there's national security dimensions, and it is about threats to Canada, that there is no doubt information that I am not aware of, or at least the government will say, and this is one of the things that I would recommend some of the work by, people know Leah West, who's a professor at, I think she's at Carleton or Ottawa, I can't remember, but on national security, and has done a lot of blogging and work in media work around this question. And she's quite critical of whether this threshold is met or not, but she openly says, look, that there is, there may well be information that we don't know about. But that's why we have these oversight mechanisms. That's why we have the parliamentary process, and that's why we're going to have those. But there are, I think, some very serious worries about whether even those processes are going to get all the information that they should have before them. And Canada has a long history, unfortunately, of over classifying information. This is what the National Security people who I've read will say that there's a long history of this. We have material that is classified as top secret that could be at a lower level, and material that gets classified at all that should be unclassified. And so there's real questions about whether these processes are actually going to roll out in the way that they should, and that Alan Borovoy, I'm sure, back in the 80s intended. And then for me, as a normative matter, I do worry about the use of emergency powers, but I worry most about about who is likely to be impacted by that, as I was saying, that because we already have all the regular police powers that are used so forcefully against Indigenous land defenders, environmental groups, anti-globalization activists, Black Lives Matter. There's incredible surveillance of Indigenous people's activism in this country. Cindy Blackstock was surveilled, for many years. These are things that exist already. So normalizing further powers, I do worry about.
Other thoughts on that question?
So I have a few thoughts. The first is how tantalizing it is to think that this legislation could be found unlawful simply on statutory interpretation alone, on the basis that the thresholds might not be met. But I know that's not where we're going to go. But it does make me think of the pre-charter world. And there's something about the situation that reminds me, for those of you who can dredge their minds back to it, to the patriation reference, where the Supreme Court found that patriating the Constitution unilaterally was unconstitutional in the conventional sense, but the feds could go ahead and do it. And there's something of that paradox here where I think there are very strong arguments that both in the ordinary sense and in the charter sense, there has been unlawful executive activity here. Of course, there are arguments on the other side, and I'm mindful that I wasn't in Ottawa and I wasn't in Ontario, and of course, some of our views depend on where we're situated. But there's the sort of legal answer, which is, boy, it sure doesn't look all tickety-boo. And then there's one's political sensibilities, which is what had to be done. And so all I want to say is to keep that tension in play. What I would say, though, is I don't know how well the courts will do their job, given that courts are very deferential towards reviewing these kinds of exercises of power, and this is at the highest level of the executive. So one would want to be not too rose-colored glasses about judicial review either.
Agree.
Yeah, I mean, I completely agree with that. And I'm watching very closely what happens with the court challenges and the other sort of post-review mechanisms for this. I mean, on the flip side of the question about is this a good use of state power, I mean, I absolutely share your concerns, Deborah. I also think it's a really difficult position that I don't think the federal government contemplated. I don't think it was in the contemplation of this act, of the Federal Emergencies Act. What happens if a province is just completely unable to appropriately deal with the situation?
Unwilling or unable?
Let me finish. Or is complicit, even more provocatively, is complicit in perpetuating the emergency on the ground. And what is the role for federal in our federation, right, for dealing with a situation like that? And so I think that's sort of a bigger question that gets provoked by the interplay here, right, and how we have to think about that in the face of the sort of new dynamics, the new influences from, you know, the far right that Deborah is pointing out in her remarks. So, I mean, that's not what this act was designed for, right? The legislation is structured on everybody sort of exercising their powers in good faith, and I think there are questions about what was actually going on at the local and provincial level here. And then if that's the case, given that there are very real rights and freedoms that are being trampled on the ground in Ottawa and in other places, right, by the occupation, is there an appropriate role for a federal emergency response? So.
A healthy dose of legal realism. Other thoughts and questions in the room? We have one from Professor Hoy Kong.
Such great presentations. Thank you so much. Other intelligence. Jocelyn, Professor Stacey. Just on the hypothesis, so the degree of coordination in an emergency will be dictated by pre-existing intergovernmental relations. So I think that's probably right. But I wonder how you orient pre-existing governmental relations to prepare for an emergency, right? So I think in general, intergovernmental relations, you have either jurisdictions jockeying to safeguard their jurisdiction.
Yeah.
Or if you have intergovernmental relations, they're over a matter of like sort of ordinary course of things, right? So there's massive mechanisms for intergovernmental relations. So I wonder if the way to handle a state of emergency on the coordination front is not to rely on pre-existing relations, but to consciously turn governmental policy to preparation for emergencies and to have the mechanisms of intergovernmental cooperation prepared in advance. That's just a kind of friendly amendment to your hypothesis, right? Not that we rely on pre-existing ones, but that we rather be fashion relations in anticipation of a state of emergency. Just another kind of federalism point. I think there's, on the panel, there's this kind of question about what incapacity means. Right? So in general, in federal jurisprudence under either a national concern branch of HOG, right, or, well, let's just say national concern branch of HOG, right? Inability.
National emergency
means two different things, right? It means, like, literally you can't do it.
Yeah.
Or failure to do it results in a regulatory failure.
Yeah.
And I think that in the emergency context, we have both, right?
Yeah.
There are circumstances in which incapacity means, like, literally the provinces or lower jurisdictions just can't handle it, right? Or unwillingness means that the emergency cannot be addressed.
So I was hoping you'd weigh in on that. The parallels between the national concern branch and sort of thinking about provincial inability in the context of emergency powers as well. I think that's really useful. And I think, the point that you made, Hoy, about sort of fashioning relations in anticipation of an emergency, I mean, that is my whole being, as you know. I'm always thinking about what the climate crisis is about to bring down upon us. And so I think that's right. That tracks where sort of contemporary disaster scholarship is, which is that we actually undermine our ability to respond in an emergency. We only focus on the response, and that really the focus needs to be on mitigation and preparation and our intergovernmental. We do need to be reorienting public law frameworks around that. Particularly do that kind of preparation. But I also think that the more practice you have at cooperation, the better you are at it, right? And so if there are other mechanisms there where governments are used to working together on issues of, common concern, then I would hope that would certainly kind of bleed over into other contexts as well. And there's some signs of that with the work that I've done with the Silkwa team and thinking about those tripartite governmental relations, which is the context in which been focusing on this. But yeah, I accept your friendly amendment. Thank you.
Are there questions in the chat? I don't know. It looks like there might be.
Not yet, but questions on chat are very welcome. Professor Kong, any reactions
Else over here.
That?
No, I think it's right. I think that when I was thinking about intergovernmental relations, I was thinking like literally provincial, federal, less federal, municipal, and provincial, municipal. But I think the big gap in sort of routinized intergovernmental relations is between indigenous orders and all other orders. So I think for those circumstances in which emergencies arise there, then I absolutely agree that we need routinization for help. Yeah.
Wonderful. Any other questions in the room or on chat, online? I'm happy to jump in with another question as people think up theirs. So I wonder, does Canada face a greater risk in light of what has happened recently of manufactured emergencies, which Professor Robert Tsai in the US defines as, quote, public policy problems whose nature and scope is fabricated or exaggerated beyond reasonable parameters? And in particular, is there a risk given social media and how quickly disinformation can spread that political leaders in the future may be able to more easily manufacture emergencies and bring power on the state to bear on them?
So if we went back to the slide on the political thinker Carl Schmitt, embedded in his thinking about states of exception and states of emergency was the idea that your style of politics would devolve into a series of friend-enemy distinctions in which it was in the interest of government to control who they considered to be an enemy. So I think we should always be worried about that logic in politics, and that was certainly present in the Ottawa blockades, because we've seen the polarization of politics globally, but certainly between far right and other ideological positions. So I do think that we are going to face more of that in the future. And that's exacerbated by social media. And so I think the example that Professor Parkes brought up about Jason Kenney and the anti-Alberta energy campaign may be the canary in the coal mine signaling those sorts of exercises, which are not under emergencies, but are actually part of that political climate that seems to come with emergencies, of attempting to control and suppress dissent, or to suss out the financial information of groups that you disagree with in order to shut things down. So I am concerned.
I mean, it seems that social media and social movements have been such a big part of the Freedom Convoy puzzle that future activists in this space, for whatever cause, may find it fruitful to give an impression of emergency or to create an exaggerated sense of threat or fear and what that might mean for political decision making in Canada. I think it's an important puzzle to consider. Other thoughts or questions from the room or online?
We should probably wrap up just because there's going to be a class in here.
Excellent. So we have just a few minutes. Any final thoughts from our panelists?
Not really, but, you know, I guess I do think, like, my point is context matters. And I think that, and that thinking about the way that, and the law and kind of liberalism in charter interpretation and all of that is very much often premised on the idea that, you know, protest is a thing that we know what it is and it looks sort of the same in all contexts. And in fact, it's not, right? And that when you have a protest that is connected to police and military, and you have support for that protest in very different ways than we have seen in with respect to other protests, where they're completely, you know, villainized by police and you know, kind of those, and security establishment. I think that's something we need to really attend to in this context, and I think it's one of the layers of context that matters, but it's one that I feel we might lose sight of in some of the charter analysis and in some of the oversight to come. So I hope we can keep that, you know, and I don't say I know exactly what that means, but I think it matters, right? And I think it matters for who's going to be most affected by these, you know, kind of measures in the future.
Maybe I just add to that the context matters. I also think justification matters, right? And the kinds of justification that we're demanding of the circumstances in this case, we should be thinking, as Debra has said, about why those haven't been relied upon, haven't been demanded in other cases, right? And looking to expand, right, out these what should be at the sort of underpinning of our constitutional system for the justification of state power.
Thank you to you guys. And thank you guys.
Thank you all, everybody online, for joining us and in the room. Please follow our events page for future events on timely matters, and have a great week.